Morning, everyone. I'm Juliet Price, and I've been in HR and employment law for over 30 years now. And 27 years ago, I founded Park City Consulting. Park City's purpose is to partner largely with SMEs, but we really are the champion for business owners, directors, and senior managers. We support you to manage and develop HR, health and safety, and management and leadership skills within your business. And this really gives business owners back the control of their business and the confidence that they have happy and healthy work environments where their people thrive, and the business really delivers the results for the shareholders. So that's our purpose. And following the webinar that we did in February this year, that was a huge success. Lots of people saying, do lots more webinars, please. And certainly everybody wanted another employment law update. So we covered in February, the first half of the year, all the legislation from January to June. And today we're going to cover the second half of this year. So really sort of June, July onwards up to the end of 2024. As I said in the last webinar, but I'm going to reiterate it, it really is 2024 an unprecedented year for employment law changes, both in terms of the volume of the changes, but also how they impact you as an employer. But that's why we're here. We're here to give you a summary of the changes and the actions that you need to plan for. So we'll cover all of that in today's webinar. A lot of people asked why there is so much this year, and the government has been making changes to employment law really since Brexit and the workplace agenda, which seems much more focused on well-being, mental health and flexibility. However, don't worry, Park City has got you covered. Whatever support you need, we are here to help business owners, directors and managers. If you're already a client of Park City, then rest assured that our HR business partner team will be going through these changes with you to identify the specific actions needed in your business and then implement the changes. If you're not a client, please get in touch today. We will talk you through how easy it is to sign up and take all of this stress and worry off your shoulders. These are your hosts for today, so please ignore the fact that below my camera it says Izzy McCartney. That's my colleague Izzy, who's sat to my right. Myself and Sam are your hosts today, so I'm Juliet Price, as I mentioned earlier. Sam Parcell is going to be joining us for the Q&A. She's a senior HR business partner within Park City and will be supporting, as I said, further on in the webinar with the Q&A. Let's have a look then at who you all are. So this pie chart is who you are. So this basically, those that have got over 200 of you logged in today, when you log in and you input, the type of the sector, industry sector that you're from, the webinar software gives us a little pie chart that you can see there. And I can see that we've got some clients logged in. So welcome to our Park City clients. We've got some non-clients, business owners, directors, managers, HR managers. We've even got HR consultants joining today. All of you I know want an employment law update. That's what you're going to get. And you're all very welcome, very warm welcome to all of you. So we have got, as always, quite a lot to cover. So let me recap, first of all, on what we covered in the previous webinar, just purely a list. You can see there the employment law roadmap up on your screen. As I said, last time we covered working time and holiday changes, right to work checks. I covered the national minimum wage increases, national living wage increases, holiday for irregular hours workers and pay changes there that came in or are coming in. The new carers leave, we covered that. Flexible working, the changes around that. Redundancy, family friendly rights, whole raft of changes, and of course paternity leave. quite a bit that we covered last time. And if you haven't yet completed your updates, you know, your changes to policies, updating and training your managers, giving them a briefing, please do get in touch. We can do manager briefings, update your policies, support you every step of the way. Alternatively, you know, if you want to DIY, contact us. We can send you the webinar recording. And obviously in that, I'll be going through all of the first half of the year. Today, let's look at what we're going to be covering today. So now we're looking July onwards. We are going to cover the CHUPI, changes to the CHUPI regulations. We're going to cover the new code of practice for fire and rehire. There's a new Workers' Predictable Terms and Conditions Act. There's the pensions extension to auto-enrolment. Potentially coming in. There's Employment Allocation of Tips Act. That's a new piece of legislation, new rules on tipping. There's the Worker Protection Amendment of the Equality Act. Everyone shrinks a little when we mention equality because it's such a huge piece of legislation. There is an amendment to that act that we'll talk through, which brings in a new responsibility for employers to safeguard against harassment in the workplace. There's a new new Neonatal Care Leave and Pay Act. And of course, that's a huge list, but in the autumn, dare I say, we're having a general election, as you would all know. The headlines still seem to say that there will be a Labour government potentially voted in. There won't be any politics at all on this webinar. That's not why we're here and not what we would do anyway. But purely, I will go through a list of the potential changes as it looks like Labour could win the election. And if they do, there is, they have published a whole raft of changes they'll be making. We'll cover that towards the end of the webinar. So our purpose today is to really get you prepared. That's why we're here. We're giving you the material, get you prepared with an action plan so that you can know what actions you need to take and obviously go ahead and implement those within your business. We've also noted on each slide, so there'll be a little blue box that talks to you, that gives you the action plan. And below that is a red box that talks to you about the risks in your business. It's always important as business owners, directors, you've got to understand what your liabilities are, what your risks are, as you would expect. We'll cover those just so that you're aware what the potential issues could be if you don't take any action. But we are here to take the pressure off your shoulders. So please get in touch, become a client. We'll take all of that issue away for you so that you can really focus on running your business and making 2024 the best business performance you've ever had. That's our goal. Let's look then at the first change, which is the CHUPI regulations. Okay, so let's start first of all with what is CHUPI. This is the Transfer of Undertakings Protection of Employment Regulations, known as CHUPI. The regulations provide protection for employees when a business or part of a business changes the controlling party. So this is a business transfer, merger, acquisition, or it can be when a business is involved in an outsourcing or insourcing a service. You know, a service provision change. As you probably would already be aware, under CHUPI, there are two parties involved. There's the transferor. This is the person that carried out the business activity before the change, and the transferee, who is responsible then for taking on the business requirements after the change. And there are certain rights that employees have. That's what this legislation's for, to protect employees when a transfer occurs, for them to take their terms and conditions with them. But the changes to CHUPI that come in on the 1st of July really are around the responsibility on the transferor and transferee, the organisation, the employer, to consult. Okay, and the changes around allowing businesses with less than 50 employees, they will be allowed from the 1st of July to consult directly with employees under CHUPI without the need to elect reps. So that could save a huge amount of time, process. It's going to save a lot of cost. So if you have less than 50 people, CHUPI applies in a particular acquisition or merger that you're doing or service transfer, then this is quite important change for you. It also includes any business of any size to allow them to consult directly if less than 10 employees are going to transfer under TUPE. Okay, but those changes to consultation only apply if you don't already have employee representatives elected. Okay, so if you've already got reps elected within your organisation, it doesn't apply anyway. You've got to use the reps that already exist. We've got a lot of TUPE experience. We do a lot of mergers and acquisitions for our clients. And a lot of our clients are very acquisitive. So we're doing this on a reasonably frequent basis. We've got a lot of experience. It is a huge piece of legislation, and there are set processes to follow. If you think TUPE applies to you, do get in touch. We can step you through it step by step. So the actions on the blue box, always take advice. So if it's not from us, pick a partner, and if TUPE applies, make sure that you use that support to follow the process. Review your staff numbers, see if this change applies to you. And then the risks, of course, there's always the potential of a claim. If you fail to consult, then the outgoing and the incoming employers, both of which can make a claim, and the employees, and then the award of 13 weeks of uncapped gross pay for each individual. So, it's worth getting it right. So that is TUPE. That's the 1st of July. Let's have a look now at the next piece of legislation, which is the fire and rehire. Again, this is July. From July, this applies to England, Wales and Scotland. The UK has its first statutory code of practice being introduced on dismissals and re-engagement, also known as firing and rehiring the same people. So the code imposes an expected procedure. So the code basically is saying this is the procedure that an employer needs to follow if they're going to use fire and rehire. Okay. The code demonstrates that fire and rehire should only ever be a last resort. So the idea is that you have meaningful consultation with employees or their representatives first. Fire and rehire, of course, has been in the headlines, not favourably, because some employers, perhaps you'd say, have sort of really mistreated it, and used it, perhaps in inappropriate ways. But it can have an appropriate, legitimate purpose. The purpose of it is to make contractual changes to an employee's terms and conditions. And basically what it means is you end one employment contract and rehire the same employee on a new set of terms and conditions. But the bad press really is what's created this new code of practice, because the government have said, right, we don't want this mistreated. Let's have a code of practice with a bunch of reasonable steps. These aren't my words. These are the words in the code of practice. They are reasonable steps. You may not agree that they're reasonable, but that's what the legislation says. So, and also bearing in mind, a lot of people think of kind of fire and rehire and the P&O ferries, bad press on this particular issue. But this new code will apply if you're using fire and rehire just for one employee. So this isn't a code that's only going to apply to large companies. This applies to the very smallest SME. Okay, so if you're going to use fire and rehire as a means of changing terms and conditions, you need to apply the code. Okay, so as you know, in exceptional circumstances, where there's a genuine and pressing business need, and an agreement can't be made, because the consultation always should be, the purpose is to get an agreement with the employee. Look, we need to make these changes. Let's agree so that we can move forward amicably. If that agreement can't be reached, then of course, this is a way of unilaterally changing terms and conditions. But there's a step-by-step guide. You can see on the actions, review the code, update your current policies, make sure you do meaningful consultation, the tribunal claims, if any come out of this, if you haven't followed the code and you are found in breach, then the employment tribunal has the potential to uplift any award by 25%. So, you know, obviously, I appreciate you all want to get it right in the first place. That's fire and rehire. Let's move on to Workers' Predictable Terms and Conditions Act. Okay, so again, in England, Scotland and Wales, it's anticipated that the right to make a request for predictable working patterns will come into force in September 24 this year. Now, this act is largely relevant to employers that employ people on 0 hours contracts, for example. The right will apply to workers, including agency workers, and the workers will be able to make 2 requests for a predictable set of terms and conditions within a 12-month period. So this is not just your employees. If you have agency workers, it also applies to them. In the initial guidance that ACAS has sent out, this indicates that workers will be protected from any detrimental treatment because they've applied for a predictable pattern or contract of employment. And this must follow the appropriate procedure, which will be clarified in this code of practice. So if you want a copy of the code, let us know, we can send it to you. There'll be a minimum service requirement of 26 weeks service for an employee to make a request. So if you've got, these are the actions now, let's look at those. If you review your workforce, if you do use 0 hours workers, have a look at how many of them you've got, how big an issue, do a risk assessment, how big an issue is this for your business? Assess the feasibility of any of those 0 hours workers. Do they generally tend to work the same work pattern? Are they usually in on a Tuesday and a Thursday or whatever it is? And if they are in on a regular work pattern, it might be worth looking into, consulting with them and updating your contracts, moving from 0 hours to predictable. And if you've already obviously got people that are on those regular terms and conditions, 0 hours may not be the best set of terms and conditions for you at this point. Thinking that through, there was one workaround that I did think of the other day. I don't know what you think about this. Put it in the chat if you think this is a really, really bad idea. But I guess from an employer's perspective, one way around this, if you're nervous to, for a 0 hours worker, because you think, well, actually, I want the flexibility of 0 hours. What if the work reduces next month or whatever, and you don't want to give them a predictable contract? I guess the workaround a lot of employers might think of is, well, I'll just give them a 1 hour per month contract. That's a predictable, that changes it from 0 hours, doesn't it? It makes it a predictable, it meets the code. But I don't know what you think about that. Perhaps pop in the chat, tell me if you think that's a really bad idea or a really good idea. But that is a workaround. That's what we've got to think of. So what are the risks here? Of course, a tribunal claim. And if there was a successful claim and it was considered to be an unfair dismissal situation, then, as you know, the current award for unfair dismissal is no more than 1 year's pay, or the cap of £115,115. That isn't a typo, that is the current cap for unfair dismissal. So that's workers' predictable terms and conditions. Let's move on from 0 hours on to proposed in the autumn is the extension of the auto enrolment. We don't know that this is definitely coming in, but it is proposed. It did get royal assent in September 2023. As you know, as soon as something gets royal assent, it usually comes in within 12 to 18 months following that. So they are predicting this autumn. Let's get prepared, because obviously obviously, when I talk it through with you, it will be potentially an increased budget that you need to prepare for. And that's what we're here for, to get you prepared and make it easy and straightforward. So the pensions extension of automatic enrolment bill, which is a private member's bill, would amend the Pensions Schemes Act to give the Secretary of State powers to amend the age limit, both the age limit and the lower qualifying earnings limit for auto enrolment. So what that means is you've got to look at the eligibility here. So it's going to bring in the eligibility of the age group 18 to 21-year-olds for them to be able to auto-enroll onto your auto-enrolment pension scheme, and potentially abolishing the lower earnings limit, lower earnings level as well. So what are the actions here? Well, you need to review your pensions policies. Also, if you've got an HR software where you can look at your stats on your age demographics, that will really help. You know that we have Breathe HR, which is a really good tool, HR software tool that we would use with all of our clients. And we will look at those with clients and see what the age demographic is, how much of an issue this is potentially for you, because that's going to create, give you the opportunity to kind of budget for this increase. If you are an employer that employs lots of 18 to 21-year-olds, obviously this is going to have a bigger impact on you than others that already, their workforce is already auto-enrolled. What are the risks? Well, the risks are the risks for not following the auto-enrolment rules. There are fines. Failing to comply with pension regulation for auto-enrolment is a fixed penalty notice of £400. That might be issued if you're in breach of this regulation. That is then followed by an escalating penalty notice, which starts at £50 per day up to £10,000 per day, depending on the number of employees that you have. But, you know, I know all of you would want to, you know, make sure that you're following the regulations anyway. So no one's going to be doing that intentionally, but obviously this is preparing you for that change. Okay. Let's have a look now at a brand new piece of legislation. So this isn't a change to an existing regulation. This is new. So this is the Employment Allocation of Tips Act. Now, the Tipping Act, as it's referred to, was granted royal assent on the 2nd of May 23, and it amends the Employment Rights Act 1996. So it's quite significant in that regard. Now, this was due to come in on the 1st of July. So those of you that logged in to the February webinar will have heard me saying it was coming in anticipated 1st of July. That's now been pushed back and it's now been moved to the 1st of October. So obviously this piece of legislation only really applies to you, largely businesses that are in the hospitality sector, beauty industry, hotels, leisure, catering, restaurants, pubs, you know, theatres maybe, those that are involved in organisations where tipping is common practice will, you know, come under this new code of practice and all the statutory requirements. So for clarity, service charges, tips and gratuities are all included and covered by this new act, and it imposes basically a set of obligations, a step-by-step set of practices that an employer has to follow, only where the employer has control over the tips. We'll come on to that. So it brings a ban on employers keeping the tips. The tips now all have to be passed on to the employees. Under the Act, employers are required to pass on all tips to workers. Employers of businesses where tips are common practice, they have to have a policy for how they gather the tips and how they allocate the tips out. And workers have a new right to actually have a copy of their tipping records. So you have to keep records of the tips in order to enable them to bring a claim at employment tribunal where they believe they're not receiving the tips that they should be. And this is applicable to employees and agency workers. So again, you know, if you've got, you know, service engineers, employees that are going into people's homes, you know, often tipping happens. You may not be aware of it, perhaps. You know, you need to find out because it's, you know, it's now got this new statutory code. Employers will have a number of responsibilities, as I've mentioned. They've got to demonstrate that all tips are paid in full to workers within 1 month of receipt of the tips. And they have to write a written policy that's clear and transparent and well communicated through their workforce. They've got to demonstrate that they've got the policy and communicated it. And the code requires employers to keep records of all the tips received and paid. They've got to keep those records for 3 years. All right. So not only have you got to keep them, but you've got to continue to maintain those records for up to 3 years on your allocation and distribution between each worker, and workers have the right to see their own record. Now, not all tips, I mentioned at the beginning, not all tips are under the scope of the Act, and therefore not all of them are subject to this code of practice. So if a worker receives a cash tip directly from the customer with no employer control or involvement, then the tip is outside of the scope of the Tipping Act and this code. Also now, you're probably aware that digital tipping now occurs, whereby a customer uses an app to directly pay a member of staff a tip, bypassing the employer altogether, and that's outside of the scope. So, you know, those organisations where service charges are applied automatically, you know, on the bill, you know, they're going to have to look at their point of sale systems and processes, because all of those, you know, they're going to need to be able to record and report on the service charges gathered and how they were allocated. So looking at the actions you can see there, review your tip collection practice, compare it to the new code, update or draft your new policy, keep your records for up to 3 years, communicate your policy to all your staff, train the managers. Really important. That's the bit that often, you know, a lot of employers we see, you know, they might have the policy, etc., but the communicating with employees and the training of the managers, that bit gets missed. We do managers briefings for clients. That's a really quick and easy way to get those messages across effectively, as well as having obviously a good quality policy, etc., in place. Also communicating to all people. Again, if you have an HR software platform, you know, these sorts of new policies, it's really straightforward to post them on the HR software platform and then monitor that all employees have read and understood that new policy. So that's really helpful if you're, you know, if you use the HR software Breathe through us. If you don't, give us a shout and we'll talk you through it. Let's have a look at the risks. So what if we do nothing? If we just carry on as we are, don't do anything, what's the risk to your business? Tribunals can order employers to pay the tips, not only to the employee that's making the claim, but also to all the rest of the employees as well. Employees can make a claim to tribunal within 12 months from the date the employer failed to pay the tip. So as you know, normally employees have a 3-month window to raise an employment tribunal claim, but for this new act, they've got a 12-month window. Employment tribunals can also, you know, ask or impose that employers have the policy in place, so they can make employers change their tip allocation process and policy. So quite far-reaching problems there. And also, as you can see, there's a compensation award up to a maximum of £5,000. So at least you're aware. I'm sure all of you, lots of clients have been getting in touch on this, so we're already ahead of the game for clients' policies and things. But get in touch if this is new and you know you need this support. Let's move on from tips, because I'm aware obviously that doesn't apply to everybody. Let's move on to a new piece of legislation that does apply to absolutely everybody. So yeah, let's listen up and step through this one. So the Worker Protection Amendment of Equality Act 2023. I did say, you know, whenever we look at equality, it is a huge piece of legislation. Whenever there's a change, that's always huge and far-reaching in terms of its impact on employers. But, you know, before we step through it, there's an awful lot of legislation to react to. But let's look at this bill. It is going to strengthen the existing protection for workers against sexual harassment. The new law will place a new duty on employers to take reasonable steps to prevent sexual harassment. of their workers, not just in the workplace. For the first time, ever, employees will be able to make a complaint directly to the Equality and Human Rights Commission, the EHRC, without having first had to make a complaint to their employer. So you could be blissfully unaware that sexual harassment has happened to one of your employees, and the first you hear about it is you have the Equality and Human Rights Commission contact you saying that there's been a claim and a complaint. Then the next thing employers must do is be able to explain and provide proof of, and those aren't my words, these are the words directly from the code. Employers must be able to explain and provide proof of the reasonable steps they take to prevent the sexual harassment of their employees. Okay, so in order to be able to explain them and have proof, you've got to have them and have carried them out in the first place, of course. And employment tribunals, this is the next element, will have the power to uplift sexual harassment compensation by up to 25% where an employer is found to have breached this code. Okay. Let's just, first of all, just because this is so important, let's just step through what is harassment and what is sexual harassment. Because in order to follow the steps, obviously, you've got to have a definition of it. So let's start with that. So harassment covers unwanted conduct related to a protected characteristic, which has the purpose or effect of violating a person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. Now, sexual harassment is unwanted conduct of a sexual nature that has that same effect. Now, it's worth noting that this is really surprising. I found it quite shocking. The scale of sexual harassment experienced by sections of the workforce. 1 in 2 women and 7 out of 10 LGBTQ plus workers have experienced sexual harassment at work. Now, this new law would have also had an employer's liability for third-party harassment. That part the government has dropped. However, it is important to understand that the new preventative duty still requires employers to take reasonable steps to prevent sexual harassment by any perpetrator, and that includes third parties. So even though there won't be, an employer's liability for third parties, you still have to take reasonable steps to prevent sexual harassment. So let's talk about who are third parties. That's your customers, your clients, members of the public that your employees would come into contact with as part of their role. So what actions should you take? Well, the EHRC has published guidance and a 7-step plan for employers. Get in touch, pop in the chat if you want a copy of that, and we can send that to you. I'm going to step you through what the actions mean in real terms. So first of all, it's all about organisation, your company culture, the culture within your business. What is culture? That's all about how people behave, isn't it? What the vibe is. This all starts with the senior leaders in the business. So you have to look at the senior leadership team. That's all of us as directors. And it's your role as business leaders to have a direct influence on the culture. You will set the tone and the expectations around behaviour for what's acceptable and what isn't acceptable. This is about leading by example with behaviour that really underpins dignity, respect, and inclusion. Then think about your policies and your procedures, how you implement those policies. A formal policy, of course, on its own isn't going to change company culture. We know that. But it's still important to have those written policies, and you have to have, by this code of practice tells you have to have. But these should really set out a definition in your policy, what sexual harassment is, give examples of it, and outline everyone's responsibility, every employee's responsibility for preventing it and tackling it. These policies can also then be used, of course, for promotion, for guidelines within the business, to let everybody know, communicate to everybody what's acceptable, promote the organisation's commitment and practices to prevent and educate the workforce, about this. And obviously, it's potentially very complex, sexual harassment. To one person, what may seem like banter, to another person is sexual harassment. So it does need defining, it does need clearly identifying. And we recommend that you have, because it's sensitive, that you have a separate policy for it. So, you might want to consider that. How do you go about communicating it and training it? Well, you have to do that as part of the 7-step process. You really want to be having regular briefing sessions, posters up in the office, to explain to people, what this behaviour is that you don't want, and that there are channels to report it, and good quality investigation will happen if it is reported. So think about your reporting channels, as well as training your managers, and making sure that you've got good investigation processes. These reporting channels will need to be well communicated. If you do have to investigate an allegation of sexual harassment, it needs to be done really quickly. A thorough process needs to be fair, with a clear message sent out that such behaviour will not be tolerated in your organisation. Line managers have a really important role in this. We need to make sure that we clarify for line managers what their role is in identifying, challenging and dealing with unfair treatment, including sexual harassment. They need to have the training, education and guidance, and the confidence, actually, to tackle this. Because sometimes they might have the policy and they've read that, but it's the confidence in what to do, what action to take. And that's where, we can train and give them management briefings. Monitor and review. So you've got to monitor this. That's another part of the 7-step process. You've got to monitor, have a look. Basically, again, you can use your HR software to monitor the gender diversity in your organisation, at all levels, including for recruitment and promotion. This will help to highlight if there are any potential, what the potential risks for discrimination or harassment might be on grounds of gender. You could look at staff attitude surveys to ask people, get their feedback in areas like gender equality, bullying and harassment. Have a look at your induction and onboarding process. This is really crucial. Ensure that it includes making new employees aware of your policies for sexual harassment, what it is, how to avoid it, making sure they've read and understood your policy and they clearly understand it. That's really important, so you can demonstrate that you've communicated and that people have read and understood what it is. Again, you can do that through the software very easily and in a very straightforward way. Make sure as well, really important, you have probation reviews. They are so crucial in this process to make sure that, we're monitoring people's performance and their behaviours, okay, and talking to them and discussing with them what's good and what's acceptable and what's not. We're here to help. We can, looking at the actions, review your policy. We can support you with that, updating or redrafting. You need to implement the ECHR 7-step prevention plan, brief and train your managers. The risks, what are they? Well, it applies to all companies of all sizes. And employees can bring a claim against the employer to the EHRC. Actually, that was the wrong way around, isn't it? But never mind. Sorry, that distracted me slightly. The tribunal claims also, there's a potential for a 25% increase if an employer is found to be in breach of this code. Then compensation, the tribunals can uplift that by 25%. And of course, there's the risk to your reputation. Nobody wants to have, this kind of claim against their company. It's just not good practice, is it? And won't give you the opportunity to be seen as a really good employer with a really good employer brand, which I know all of you want. So that covers the Worker Protection Amendment of Equality Act, your responsibilities to protect your employees from sexual harassment. Let's look now at the changes to neonatal care, leave and pay. Actually, this isn't changes. This is a new Act that's coming in. It's October, coming in October at the earliest. This applies when an employee has a baby, or they are the person with parenting responsibility for bringing up the child, for a baby who stays in neonatal care. Okay, there's a maximum of 12 weeks paid leave and a minimum of 1 week, and this can be added onto maternity leave. It's a brand new care leave, and it'll be a day one right when it comes in. But to qualify to be paid for that leave, there are service requirements. So the employee would need to have 26 weeks service, and statutory pay for the period will be the lower of a week's pay, or statutory maternity pay or statutory paternity pay. Both parents can have this neonatal care. Fathers and partners can share some of this alongside shared parental leave, so both partners can have the ability to prioritise family at what would be a very difficult time. The baby must be in neonatal for a continuous stay of at least 7 days for the employee to qualify for the leave. They must have been admitted to hospital within 28 days of their birth. Now, we've already drafted a full suite of documents on this. These will be available when the Act comes in. Of course, there's no point in publishing those to you in advance because they could change. But obviously, if you're a client, you don't need to worry about any of this. You've got an awareness from today's briefing, but obviously, all of your policies, everything will be updated by us. There's a number of policies, as you can see from the actions there, a number of policies to update: maternity, paternity, adoption, shared parental leave policies. We need to update those with this new neonatal leave and pay as another right, communicate to staff and train managers as well. What's the risk if you do nothing and don't update your policies? Well, obviously a tribunal claim for discrimination is the ultimate risk on this one. Just also to say, there is currently no guidance on whether employers can contest or refuse an employee to take the leave. However, the guidelines are likely to be very similar to that of statutory maternity leave. These could include things like a written notice to the employer requesting the time off, as well as evidence of the child's birth and medical records. So, you can get evidence of that. Now, that covers the list of new and changed employment law that we know about for the next 6 months until, of course, the general election. So what to expect? This is not a political slide by any stretch of the imagination, but we can't ignore, as employers, you need to be aware of what could happen in the autumn. We're definitely having an election, as you know, but what could happen? All of the press is still saying they believe that Labour will win the next election, and you need to be aware that if that happens, these are the things that you need to be aware of. If Labour win in the autumn, in their first 100 days in office, they have said they're going to introduce their Employment Rights Bill, and that's obviously 100 days, only about 3 months, isn't it? They've said they'll introduce a number of employment law changes because it's part of their New Deal for working people. This will include lots of change. So potentially employee status will be changed. There'll be a single status for employees and workers. At the moment, as you know, only employees have employment rights and statutory rights through tribunal. Workers don't. That will change because workers will become under that single employee status and have the same rights as employees. The right to disconnect is the second one. This legislation's already in Europe. France and Belgium already have it in place. This basically is the right to disconnect. It allows employees to switch off from work outside of hours and not be contactable by their employer. They intend to bring that in. Unfair dismissal will become a day one right. So at the moment, as you know, we have 2 years window, if you like, within which we can dismiss somebody and they can't bring an employment claim for unfair dismissal. That will change because unfair dismissal will become a day one right. They intend to bring in dual discrimination. An employee can bring one claim for more than one discrimination. They also will bring in mandatory ethnic and disability pay gap reporting. So this means equal pay claims for larger companies. So if you've got more than 250 employees, that you should start looking at monitoring and preparing now for mandatory ethnic and disability pay gap reporting, as that would potentially come in. Also, the tribunal claim time limits. As you know, at the moment, an employee has 3 months within which to bring a tribunal claim against you. Their plan is to extend that. They haven't said how long for. 6 months would probably be the minimum, but it could be 12 or longer. And also, they're potentially going to make unfair dismissal uncapped. As you know, at the moment, it's got a cap of £115,000, but that will potentially be removed. Also, there is a personal liability for directors, so do look at your director's liability insurance, making sure that you're covered should this come in. They're going to end the fire and rehire. This practice, they'll make that illegal. And then they are going to ban, originally they were going to ban 0 hours contracts, but that changed yesterday. They're now saying they're going to ban exploitative 0 hours contracts. So a bit of a pare back on that announcement. Trade union laws, they're going to be strengthening those. So this in effect, of course, will strengthen the position of workers and employees, but is more onerous for you as the employers. Let's do a recap of what have we covered in the legislation today. So we're going to go back to the roadmap. Today we've covered CHUPI, the changes to that legislation, fire and rehire and the new code, Workers' Predictable Terms and Conditions Act 23, pensions extension of auto-enrolment, employment allocation of tips, Worker Protection Amendment of Equality Act, the Neonatal Care Leave and Pay Act, and of course the general election. Our purpose today has been to give you an action plan, all the HR steps that need to take place and the risks if you do nothing. Clients, you'll be prepared because we'll do it all for you within your existing retained service. Your HR business partner, our team are already working on it all. They'll manage it for you. Option one, if you're not a client, become a client. We'll take care of it. This is the quickest and most effective option for you. Option two is the DIY option. Implement all the actions yourselves. Obviously, that comes with risks, is time consuming and problematic. But obviously, that's an option that's open to you. We're happy to take some of your questions now. So I can see there's been some questions going through on the chat there. Over to Izzy, I think, who's going to moderate the Q&A, please, Izzy.
Brilliant. Thank you very much, Juliet. So we're joined with Sam today as well. So we just had a couple of questions come through, and one of them from Samantha Jane asking that she would appreciate guidelines. And I think this was to do with the sexual harassment piece that you were talking about, Juliet. And we'll be sending things through after the webinar, so just keep an eye out for that. Was it the 7-step?
Yeah, if you'd like that. So obviously we've got your email address. The person that's asked for that, your microphone's off actually, Izzy. I don't know if you were aware of that. Yeah. But if you want that those guidelines and the 7-step process, let us know and we can send that to you. That's not a problem.
Brilliant, thank you. And then Graham's asked, and he said, with the right for employees not to be contacted outside of working hours, does this include emails and reports? So Sam, I'll ask you that question.
Yeah, so the guidelines are still to come out on that, but we do have that in Ireland for the right for employees to switch off. However, we already put policies in place with our clients in Ireland where we put guidance down within the policies of what that looks like. So with emails, it could be that you may send an email late at night, but the employee then sees it the next day, and that wouldn't be considered that you're contacting them out of hours. It's more likely to be phone calls, text messages, WhatsApps, etc., and only when it's really necessary that you contact the employee if there's something urgent.
Brilliant, thank you, Sam. And then we've just had one more. Anastasia's asking again if they can have the 7-step guidelines too, which is absolutely fine.
You can.
We'll follow up with that. And then we've had one from Annie, who said that we mentioned dual discrimination in the potential changes when we get a new government. Can you explain this?
I'll do my best. Under the Equality Act, there's already the option for people to bring forward a discrimination claim for more than one protected characteristic. So it already exists. But what I think the purpose of it is to try and reduce down the volume of employment tribunal claims, but creating a situation where the claim would be multifaceted and include more than one protected characteristic within the claim. So there was an article, these aren't my words, there was an article in The Guardian on this very topic, and it said, if a black woman was sexually harassed. So you've got there, obviously potentially 3 forms, haven't you? Sexual harassment, gender, ethnic discrimination. So, that would be a potential claim for not just a dual discrimination, but three separate ones that could all now be brought in the one claim.
Okay. Thank you, Julia. We don't really have too much longer left. So if anybody has any more questions, please email us or get in touch. And we'll follow up with those of you that have asked about the 7-step guidelines. We've had quite a few people asking about them, so we'll make sure that we'll get in touch and send you that document. So over to you, Juliet. Great.
Fantastic. Okay, well, I really hope that you've really enjoyed the webinar today. You're never alone with Park City. We are here to help you. That's our purpose in life, to help you as the employer, advising thousands of businesses over 27 years that we've been trading. We've been giving them the right direction, guidance and management training. Have a think, are your managers equipped to handle all of this? Is your business fully prepared? If it isn't, scan the QR code. We've got offers exclusively for you today to sign up to become a new client, and some quite exciting offers that end at the end of May. So don't leave it. If you're watching the webinar and recording, make sure that you do it straight away. And if you have enjoyed it and found it useful, please go on and give us a Google review. Those Google reviews really do boost the team here at Park City, because putting on a webinar, and in fact everything that we do every day on behalf of our clients, is a huge team effort. And everyone loves to read a Google review from a client or someone that's enjoyed, advice and guidance that we've given. So please go on. Izzy is going to please put the link in the chat for the leaving us the Google review. So we'll do that. And please do give us that review if you can and get a moment. Hopefully you've enjoyed it, and you feel that your time has been well spent. And we will be having follow-up webinars. Everyone keeps saying, when's the next one? And we've got some questions gone through on the moderated chat that have said, please, can you do another one? We will be doing another one probably in the autumn. Certainly depends on how much more codes of conduct and codes of practice that come through, but also we'll also be of course looking at what happens at the general election, because that will have a big impact on all of us. So we'll see. If we don't see you before, we'll see you in the autumn. Thanks very much, everyone. Have a great day. Take care. Bye-bye.